Welcome. This is Estate Planning 101, and I'm going to go through quite a bit of material in 1 hour. I'll take questions as time permits, and just a brief intro. We're here for an hour. I can stay maybe a little bit longer, but we're going to have to give up the room at some point. I've been teaching at Cuesta since 2002. My name's Gary Rubin, and I teach business classes, law classes, and I've been practicing law in California since 1985 and in Illinois since 1986. I have been doing estate planning more so in the last year than anything else because I teach full time. I don't have time to do everything, but estate planning is of interest, so I've been doing more of that. And I put together this course for the faculty lecture series because I was asked to speak about estate planning. I said, sure, I can do that. And I like to put together an outline always just to kind of pull my thoughts together. And I set out, talk about a few different topics. And the topics we're going to touch on are these: wills, trusts, joint tenancy, small estate affidavit, which is a way of avoiding probate if you're able to fit that small estate affidavit requirement, guardians, estate and gift tax, powers of attorney, advanced healthcare directive. And you put these things together and say, these are kind of the basics. Everyone could get something out of this. But each one of these topics we could probably spend 2 hours on. So I'm going to go through these fairly quickly, but you have an outline that'll give you more detail than what I'll cover in the hour that we're going to go through this. But I'll hit the highlights on all these topics in the next hour. So let's start off. A will. What do you need for a will? In California, you need to be 18 years old. It needs to be in writing. You have to have sound mind. What does that mean? Sound mind means that you know who your family members are and you know what assets you have. It's pretty much about it. I mean, there's tests, but that's pretty much the summary of it. You have to sign it. The testator is the person who's making the will. And there have been times where we would say testatrix for female, testator for male, but it's pretty much now testatrix is gone and it's all referred to as testator in the probate code. You have to have 2 witnesses to the signing of the will by the testator. The witnesses are not there to read the will. They're there just to say, I saw this person sign his or her will, and I believe that person to be of sound mind when they signed the will. And that's it. They signed something at the back of the will that says, I saw him sign the will. They seem to be of sound mind. So when we do a will signing, the person who is signing the will, we ask them to introduce themselves to the witnesses and just say, I'm signing my will, I'd like you to witness my will, so they know, that the testator has acknowledged what I'm asking you to do. I'm here to sign my will. So it's kind of, then they can always testify down the road if the will is contested. I saw the person sign the will, the person seemed to be of sound mind to me. So those are your 5 basic requirements for a will. So a couple questions I'll intersperse here and there. If somebody says, I just went through a divorce or dissolved my registered domestic partnership, is my old will that I made while married or in the partnership still valid? Yes, it is. But anything in that old will that says I leave it to my spouse or partner, that portion of the will is revoked, but the rest of the will remains valid. Okay? So if you get a divorce right away and you think, what about the will? I forgot to do anything about that. Don't worry, your ex is out of the will automatically, by law. So what if you get married or you enter a partnership after writing a will and that spouse wasn't in your will? Maybe you wrote the will 5-10 years ago before you even met this person. Well, what happens then if you die and your will does not provide for that new spouse? Does the new spouse or partner who was not written in the will get something? Yes, even if they weren't named in the will, they get something. How much? Generally, they would get the community property because they already own half of it, but one half that they don't own, that the decedent just died with, they get that. And then some of the separate property, but it depends if there were children or not. So they will get something, but there could be exceptions to that last answer. So there's 3 exceptions. Can an omitted spouse in a will actually get nothing? It depends on what their intent was. If the testator intentionally omitted the spouse or partner from the will and stated that in the will. So if you say, I don't want this spouse to get anything, and here's my reasons why, you don't really even get into reasons, but you have to state your intentions. Okay? Or if you gave assets to the partner or spouse outside the will, and you made that in lieu of the will, that is another way that the spouse would not get anything. And then finally, if they just have a prenup or postnup, prenup or postnup, you can have a prenuptial agreement, an agreement that waives your rights to get something from your spouse upon the spouse's death. And that can be signed before marriage or even after you get married. Prenup, postnup. So, okay. Holographic wills. Are they valid in California? What are they? A holographic will, it's all in your handwriting. And they are valid in California. And holographic wills do not require witnesses. So this is kind of like sometimes people refer to a deathbed will. I just want to write something out. Is it going to work? Yeah, it'll work. Okay? It's valid. Some examples up here. I hope that you are all fine. I am not feeling well. Everything I own goes to my sister Norma. Patty Williams. Okay? That's a holographic will. The requirements are that you have a signature and material provisions in the handwriting of the testator. There's a signature, material provisions. Everything I own goes to my sister. What else do you need? You need some statement of testimony intent. The most common is what you see in wills that are prepared by lawyers usually, right at the beginning. This is my last will and testament. That's a statement of testimony intent, meaning I'm intending to give away my assets in this document. Well, I think this would fly, this right here. I'm not feeling well, everything I own goes to. That's a statement of testimony intent. I want to give my assets away at death. That's probably good enough right there as a will. Okay? You can get more detailed if you want, but of course you still have to have capacity. If somebody challenges this based on lack of capacity, it comes down to just witness testimony then. If somebody wants to challenge the will, wouldn't be Norma challenging the will, maybe Norma's brother just wants to challenge it and say, why didn't I get something? Well, you have to prove lack of capacity by Betty. Okay? Is that Betty or Patty? I think it's a Betty. You don't have to have a date on it, but if you were going to write one in your own handwriting, you probably should date it, just in case there's confusion as to a prior will. Because you can make a handwritten holographic will that revokes a prior will, but if you didn't date the holographic will, how's the court going to know if it's challenged which one came first? So you would probably be better off dating it if you're going to do one. And they're valid. I have to confess, it's almost embarrassing that I had a holographic will for my family with 4 minor sons for 20-some years until a little over a year ago, when I finally did the complete package that I did for over 100 clients over the years, and I never got around to finishing mine. And we moved from Illinois to California, 4 little kids in tow. My wife said, we don't even have a will. She was really upset with me because I did all the ones for clients I was finishing up before I closed my practice in Illinois. She's like, we don't have anything. And when we were moving out here, I said, okay, that's it. I'll sit down in the hotel room and wrote out 2 wills, about 20 pages each, with provisions of who would watch the kids, guardian of the estate, guardian of the property, what age they would get everything. Just wrote it out, and I said, just to be sure, we're also going to get witnesses at the front desk of the hotel. We'll go beyond the minimum requirements just to be sure it's solid. And I never got around to doing ours, and I just finally said, I got to get this done. I'm thinking I'm going to get back into taking clients on for estate planning. And my wife said, you absolutely will not take on even one client until ours is completely done. I said, fine. So I did ours. I finished it last August, 2018. I did the whole thing, the living trust, and put the house in the trust, and the pour over wills, and the powers of attorney, and the advanced health care directive, and so I said, okay, we're good. So, but they work. Holographic will would work. Okay. Can you do an oral will? Can you put it on a recording, on a video, on a type of tape recording? Not in California. In some states, yes, but not in California. It's not valid in California. It has to have something in writing or typed. So that's called a non-cooperative will. Many states allow it, but not California. So, what happens if you don't have a will and you die? If you're in that position, you're thinking, what's going to happen to my assets? Well, you're said to have died intestate, meaning you've died without a will. If somebody has died with a will, that person is said to have died testate. So testate is with a will, intestate is without a will. If you've died intestate, you actually have a will. The state of California has made a will for you. You can read it. It's just Google it, probate code 6400. And it depends in part on, as far as who's gonna get your assets. Are you married? Spouse is gonna get a certain amount. Do you have children? How much does a spouse get depends on how many children you have. If you have one child, versus you have more than one child, do you have a parent living? Do you have siblings living? It all depends, but the first provision is spouse gets X amount, and then that amount is determined based on who else is surviving you. It could be that you have a state of California will, this will, that you really don't want, and it could really be detrimental to the family overall. For example, a client called me not too long ago, 70-some-year-old man, and he has no children, never married. So I don't have a will, what do I have? So he was in Illinois, and I looked up the Illinois laws of intestacy, which these are called. Sometimes they're called laws of descent and distribution or laws of intestacy. But when you die without a will, every state has something along these lines. And they're very similar, most of the states. And you can find it for any state. Just look it online under probate code, Google it, laws of intestate succession. And similar to California, I looked it up there and I said, well, you don't have any children, right? No. Siblings? Yes. Brother and a sister, okay. And parents living? Yes. One parent in her 90s living in a nursing home on Medicaid, paying for the nursing home, okay. So he's in his 70s, he has a 94, 95-year-old mother living in a nursing home that's being paid by the state. And I didn't have him go through and fill out the full questionnaire. We just did this over the phone at first because he just wanted a quick answer. What happens if I die now? Who's getting what? And what it comes down to in that situation, mom gets half, his siblings get half. So I said, well, your siblings will get half and your mom will get half. Well, that's not good in that situation because mom was already having a nursing home paid for by the state. If she gets the assets, that's gone. Half of those assets are going to the state of Illinois for reimbursement of the Medicaid paid nursing home for the last several years. So that's just a waste. You need to do a will unless you want to unless it's make a donation to the state of Illinois of half your assets. And then we talked a little further, and I just clarified for him. I said, now just to be sure again, you only have one brother, one sister, any, half brothers or sisters? Well, yeah, but I don't count them. Well, the state of Illinois, just like the state of California, does count them, and they count them the same as the full blood. So he says, I have two half brothers. My father was, married after divorced my mother, had two more. I see them at wakes and, weddings, but we don't have a relationship. Your assets are going to be split one half to your mother, and then the other half, 1/8 to each of your siblings. So your full blood siblings are going to get the same amount as your half blood siblings. He didn't like that. So that's what the will is if you didn't do one. So do a will if you don't like that. Do a simple will to just at least clear up who's going to get it. And you can even do it in handwriting if you want to clear it up right away. Okay. So, all right, switching gears out of a will, a revocable living trust. What is this? This is an alternative to a will for many people. An alternative that will give you some advantages as far as avoiding probate when you die And if while you're alive you become incompetent or infirm, it avoids the need of a conservatorship proceeding. So let's just kind of back it up a bit before we get to the advantages and the pros and cons of it, just describing what it is. Revocable means you can change it during your lifetime. Nothing is etched in stone with this. It's a living trust, also known in legal terms sometimes as an inter vivos trust, during life, inter vivos. You set it up while you're alive. It actually starts owning assets while you're alive. You transfer assets into the trust while you're alive. So it is an entity in and of itself that starts owning assets. It's a trust because it's a separate legal entity that has three parties to it. The trustor or grantor or settlor, all the same. They're synonymous with each other. That's the person or persons who create the trust. So that would be you. You set up a trust, you're the trustor or grantor or settlor. You set the terms up of this trust as to here's who owns these assets or who gets value from them while we're alive. So you set yourself up as the trustee also of the trust, meaning you manage the assets of the trust. Husband and wife, you very often do one trust. And that one trust has co-trustees, husband and wife. While you're both alive, you both have equal access to the assets. You would name the survivor of the husband and wife usually as successor trustee. And then you name alternate successor trustees, so after the surviving spouse passes away, and we named our sons as alternate number 1, number 2, number 3, number 4 in an order. You could have, even after you die, co-trustees, but then you have to have consent among them and there could be some disputes, so it's your choice. But the beneficiaries are who get the income or the principal of the trust. And while you're alive, you're the beneficiary of your own trust. Husband and wife set up a trust, you're beneficiaries of the trust. So you get full use of the assets, whether it's the real estate or bank accounts, whatever the trust owns, you still have full control over, you have the benefit of it. Now it sets up where in a trust, you can now dictate after you both die, who are going to be the beneficiaries of the assets in the trust. Unlike a will where you usually have to pass it out right away at death, the trust can continue on. You could say after our life, let's hold on to it till the kids are a certain age. Maybe you say it can be used for college or it can be used for down payment on a home. You can put any purpose you want in there as to what it could be used for, the assets, but you could hold on to it. I've seen people hold on to it till they say the kids are 50, 60 years old because they want to make sure the kids don't lose it in a divorce or just kind of blow it, make sure there's something there for their retirement. So the beneficiaries that you name as successor beneficiaries, you could state in the trust when do they get it and for what reasons before that age, if at all. So, but you have three parties to a trust. So why do these? What's the benefits? One benefit is if you're getting infirm, you're starting to have some type of mental incapacity, and you have to have a conservator appointed for you while you're alive, that's going to be expensive. That's going to be a court proceeding. If you have all your assets in a trust, you don't have to worry about your assets. You already now have somebody named in that trust who will step in and manage the assets for you. And you would state in the trust document under what terms does it pass then the trustee position to the successor. So you would say whatever you want. You could say, usually what I advise and what I did in mine is, on the declaration by my attending physician or two attending physicians that are not related to me, that I'm no longer able to manage my own affairs, then the successor trustee steps in. So if the kid starts saying, hey, mom has passed away, dad's the successor trustee, sole trustee now of his trust, and he's losing his marbles, one of the kids can just go get the doctors to say, hey, look, check that out. Is he still with it? If he's not, okay, successor trustee steps in, has authority now. Without going to court, you don't have to go into getting a conservator appointed. Now this is paired up with, and we'll get to that in just a bit, a durable power of attorney. A power of attorney, I would name my children in the same order as who's going to manage my assets, as I named as trustee who's going to manage the trust assets. But the agent under power of attorney has control over assets not in the trust. The trustee has control over assets already in the trust. So if I start losing my capacity, I have the same people who I've named in two different documents. My sons in these orders can take control of assets that are in the trust as successor trustee and control of any assets that I don't have in the trust under my durable power of attorney. So you're avoiding the need to go into court if you lose your capacity. And that's one of the main benefits of a trust. Another main benefit is when you die, a will goes through probate court. The assets owned in a trust do not go through probate court. Your successor trustee can just pass the assets out. So it's not open to public inspection. The trust document stays private. It's not for people to see who gets what assets. It's none of their business. A will is public information. It goes into probate. With these types of trusts, because they're revocable, there's no income tax complications. So even though it's owned by the trust, your bank accounts that earn interest and get a 1099, they still, even though they'll come in the name of the trust, it's still taxed on your personal tax return. The trust does not file a separate income tax return as long as the trustors or grantors, husband and wife who started it, as long as one of them is still trustee, the trust does not file its own income tax return. It's just still on your personal income tax return because the IRS says it's still within your control. It's revocable. You can pull the assets out of the trust anytime you want, so it still gets taxed to you. So no income tax complications. And when you put a house into the trust, no reassessment of the value of the property, no transfer taxes. It's just, for probate purposes, it's owned by a trust. It's not owned by you individually. But for tax purposes, it stays the same. No complications. So overall, those are the main two benefits of a trust. And if you say, well, what about funding it? You have to put assets in the trust. Yes, that's very important because if you don't put the assets in the trust, really it's just then kind of an empty shell. Now, the trust will have your dispositive provisions. Dispositive provisions are the provisions in a trust or in a will that say, here's who get my assets when I pass away. How are my assets going to be disposed of? So those dispositive provisions, which you would normally put in a will, you put those in the trust. And when you do a revocable living trust, the lawyer absolutely should always be doing a will to go along with that trust. That kind of will is called a pour-over will. It's really a simple will that just says, I leave everything to my trust. And the idea is, if you set up a trust and you did not fund it, you didn't get all the assets into the trust before you die, well, at least you already had those dispositive provisions in the trust, so you don't have to restate them in a will. You could just then say, hey, yeah, my will has to go to probate, and all the probate court knows is the assets get passed to the trustee of this trust. But still, at least who are the beneficiaries, that stays out of probate court. That doesn't get, the trust doesn't get put into probate. So there's still some benefit to having the trust, even if you didn't fund it, but you'd have to go to probate to get all the assets into the trust. So you'd still have some privacy as far as beneficiaries, because otherwise, when you go into probate court, if it's just a will or even no will, intestacy, that's all public, meaning your will goes into probate and the names and addresses of all the beneficiaries in that will get identified in the probate court file. And the assets, all the assets get listed. I remember the first time I filed a will in the Cook County probate court in Chicago. All states, all counties, it's public information. So I walked in, and there's a big counter, and you take a number. And I had a gentleman's will that he recently passed away, and I was handling the probate. I was going to file the will, which you're required to do to get it started. And there were 12 or 15 clerks there who were taking people as, you wait for your number. And I saw my numbers 20 people away. I walked over to the side of the counter, and there's a gentleman who has a stack of files, probate court files, about a dozen of them. And he, at one point, was looking through one, finished it, put it on the stack, gave it back to the clerk. And he said, "Can I have 10 more?" And I was kind of curious what he was doing. He was taking notes on each file. So after about 5-10 minutes, my curiosity, took over, and I just had to ask him. I said, "Hi, are you a lawyer? What are you doing? Are you doing research?" And he reached in his pocket, and he pulled out 2 business cards, and he gave me 2 business cards with his name on them. He introduced himself. One was Joe Schmo Construction, and one was Joe Schmo Real Estate. He says, "I'm a realtor and I'm a contractor." He says, "I'm not a lawyer, I'm just doing research, I'm getting leads." Every probate file has the name of the beneficiaries and a list of assets. He says, "So I just go looking for houses. Everyone that has a house, what are the adult kids going to do after mom and dad died? They're either going to sell that house or they're going to stay in the house and fix it up." He says, "So I'm approaching those people and saying, here's my services, which one do you want?" He says, "This is how I get my sales leads." It's public information. I mean, it's good salesmanship doing, your prospecting. So you start getting the junk mail then, or the ring on your doorbell, but funding the trust, it takes work. You have to go to the banks, to the credit unions, anywhere you have an account, and you have to give the bank or credit union, "Here's the name of my accounts now, change it over." And you would give them a copy of a portion of your trust, not the entire trust. They're not entitled to the trust. Some bankers think they are. "Oh, I need the whole trust." No, you don't get the whole trust because it's a private document. You would get copies of the signature page, copies of the title page, and copies of the page or pages that says who the successor trustees are. And on top of those copies, the lawyer who would prepare the trust for you would prepare usually what's called a trustee's certificate of authenticity. One-page document that says, "I, Gary Rubin, and Kathy Rubin are the trustees of the Rubin Family Trust." Attached pages 1, 3, and 14 are pages of the trust that identify the trustees, the signature page, so forth. A couple other things you say. You staple that to the top of the copies of the pages. When you go open a new bank account, or you go to where you already have accounts, say, "I want it in the name of the trust," that's what you give them. Because the bank needs to know, well, who are we supposed to deal with after you die? So who are the successor trustees? Okay? So you give them that information. With real estate, you have to do a new deed. You have to transfer the property out of your name into the name of your trust. So the trust owns the real estate when you die. The idea is you don't want to own anything in your personal name when you die. Okay, so you start thinking, well, what about joint tenancy? Joint tenancy, husband and wife, that does avoid probate. It automatically goes to the surviving joint tenant. But then when there's one spouse left, it's owned in his or her own name, that would go through probate. So you don't want that. Okay? So you want to transfer it into the trust, and you would want to have a durable power of attorney, like I said, so that if you didn't get something in the trust, husband and wife, and one dies and the other one's in the hospital, get that stuff in the trust. Your agent can step in then under the power of attorney and start transferring assets into the trust before the survivor dies, and you get everything in the trust, you avoid probate. So, but this takes time and effort. It's not easy going to the various banks and such. Now, assets that have a beneficiary designation, such as life insurance or a 401k or an IRA, those you don't really need to be so concerned about placing those into the trust. In fact, you usually would not place those into the trust. Those are going to be paid out to the named beneficiary. So a life insurance policy, you could just have named beneficiaries and multiple. I have life insurance, and I've named my spouse as primary beneficiary, my 4 children in equal shares, or the survivor of them in equal shares as successor beneficiaries. And it takes a paragraph or so. It's not able to be fit on the usually one line they give you, who's your beneficiary, number 1, number 2, number 3. So that's fine. You say, okay, I'm attaching a paragraph. Here's my beneficiary designation. And that's who it's going to be paid out to. It's not going to go to probate court. On a beneficiary designation of a life insurance policy, an IRA, 401k, it goes to the named beneficiary. You just want to be sure you have enough named beneficiaries there. If you don't have any children, you have one spouse, or maybe one child, what you'd probably want to do then is you name your spouse, if that's who you want to go to, as primary beneficiary. If no children, then secondary beneficiary would be your trust. So if you die and you didn't have a surviving spouse and no children, and your beneficiary designation just said to my surviving spouse, and the life insurance company says, well, your surviving spouse isn't surviving, you're the last one. Who does it pay out to then? Then it pays out to your estate. It has to go through probate then. So a will would have to, even if you didn't have a will, the life insurance company is going to say, we pay it out to the estate. So a probate case has to be opened just to receive the insurance money. So you would name your trust as the final beneficiary maybe on your life insurance beneficiary form. So again, your successor trustee can then receive the insurance without going through court. Okay? But funding, it takes work. You have to get the assets in the trust. Most lawyers who set up a trust for you, they're not going to do all the funding. They'll handle the real estate. I handle the real estate. I have handled the banks. I've gone with clients to banks. And it's just a lot more time, a lot more legal fees, which normally what I do is say, here's what you need to take to the bank. I give it to you and say, here's how you change it. And if you have questions or they have questions, you can call me, but I don't need to go with you to every bank. But I'll take care of the real estate. I'll prepare a deed, have it signed, get it recorded. Anything else, you really don't need a lawyer to do it. You just need to understand what's the new wording I should put on my account. And the lawyer who does it for you should put it in a letter for you and say, here's a letter, helps you go to the bank with. And then you can take care of that. Brokerage accounts, same thing. Beneficiary designation, here's what you use, here's the language. So what about small estates? If you don't have much and your assets would not go through probate, is it still worth it to set up a living trust? Maybe, maybe not. Maybe you don't need a trust. Remember, one of the ideas of avoiding probate, that's what we're talking about here, you might not have to go through probate. Would you still have to go through a conservatorship? Maybe, so maybe you want a trust just to avoid the potential for a conservatorship. But the probate avoidance feature, that only really kicks in, that benefit, if you have more than $150,000 in assets. Because if you have less than $150,000 in California, your estate's not going to go through probate anyway. There's a procedure, it's called a small estate affidavit. You could then fill out this affidavit. You can even get it online. It's not something you have to even have a lawyer prepare. Banks have them. You can go in and say, well, my mom died and all she had was $120,000 total value of all her assets. And the bank here, you have $50,000 in an account. I'm her sole surviving son. Can I get that? Bank will say, sure, sign this affidavit to that effect. They'll give you the money. Okay? You're signing under penalty of perjury that you are the surviving beneficiary or heir, with or without a will, less than $150,000 of assets, you can go get those assets without a judge's probate order giving them the authority to give you the assets. So there's some complications sometimes with, if within that $150,000, there's a piece of real estate that's worth more than $50,000, then you still can do the small estate affidavit. You don't need a full probate procedure, but you have to file a second affidavit with the court. Again, not a probate full-blown procedure, but just another filing that you have to file with the court. But this $150,000 limit does not include several things, including a car or cars, truck. It does not even include a mobile home. So you could have more than $150,000 really, $150,000 of non-exempt assets, plus anything else that was exempt. Cars, trucks, mobile homes, those are all exempt. Okay? So assets held in joint tenancy, you don't count those, of course, either, because they're going to the surviving joint tenant. They're not owned by the decedent. So a decedent who has $150,000 in his or her own name or less, no probate. You fill out one of these. Okay? If you have more than $150,000 in assets, you might start thinking about a trust, but what are its disadvantages? Well, it costs more than getting a will done. Legal fees. You know, people will do a will fairly simply. I remember when I worked at a law firm, I was 2 years out of school, and I started thinking we should be doing trusts for a lot of these people. And the senior partner in the law firm told me, "You prohibit me from doing a trust." He said, "Don't even talk to about that with clients." And I said, "Why?" And this was an old established law firm 50 miles outside of Chicago, and they had all the power brokers in this firm. I was a young associate, and I worked in the business side of things, in estate planning, and the partner in estate planning, he was old school. He said, "You write wills. It's a small fee now, but as a young lawyer, you write wills, you get a small fee now, but when those wills mature, the probate fees that come from those wills will pay your kids' college costs." I didn't understand it at first. What are you talking about? He says, "The probate fees you get from a will, that's when you're going to make money. You don't do these trusts because then you don't get the probate fees later. They avoid probate." That's what a lot of people, you know, I mean, lawyers thought, and some of them still maybe are of that mindset, but overall, it does take more money up front. You might spend a few $1,000s on setting up a trust versus a few $100s on setting up a will. But overall, what you're looking for is no court supervision. That's a benefit, but it also could be a disadvantage. If you have problematic family relations, people looking to grab from each other, maybe a trust is not the best for you. Maybe you should have a probated estate, because you could have, in a trust situation, one child named a successor trustee. There's no court overviewing that. They could just start maneuvering assets, and it'd be like a lot easier to stick it to one of the beneficiaries, a sibling who doesn't know what's going on, is just kind of trusting. And whereas in a court-supervised probate proceeding, the judge supervises the collection of all assets and the distribution of assets according to the will or according to the laws of intestacy if there was no will. So everybody's going to get their fair share. So with the privacy comes a chance for more fraud if you don't put somebody in that trustee position who's responsible. And if you're thinking, well, I don't know about the kids, who's responsible? I mean, they're trustworthy, but they're absent-minded, they're not good with finances. Who would be a good successor trustee? You could name a bank or trust company as successor trustee. It doesn't have to be an individual. So you could say, I want still the privacy, but the kids wouldn't be really suited to being a successor trustee. And I don't know if my brother or sister would be able to do it or be, solid doing it. You name a bank or a trust department of a bank as a successor trustee. So probate, talking about the cost, these are the fees. These fees are set by statute. Now you could try to negotiate down with a lawyer, which they'd be willing to, some of them, but this is what they're entitled to. And this is just the basic fee. If the lawyer says, hey, this was a more difficult case, they can ask the court for more fees than this. But like on $1 million estate, if you have $1 million in assets in the estate, which isn't so hard to do if you have a home in California and you've lived and worked for 30, 40, 50 years and you pass away, you have $1 million, the attorney's fee is $23,000, and then the administrator or executor fee gets the same thing. So you're talking $46,000 in fees. Now, administrator versus executor. If you died with a will, and the will's going through probate, you've named somebody in the will as your executor. Who's going to manage the probate case? Who's going to gather the assets, pay off all my expenses, my medical bills, sell my house, pass out my assets? That's the executor you name. If you didn't have a will, or if you had a will but the executor you named is no longer alive or doesn't want to do the job, who does the job then? Then the court appoints somebody to do that job, and now we just call that person the administrator of the estate instead of the executor of the estate. Same thing, it's just administrator is appointed by the court and chosen by the court. Executor is who you've nominated in your will. But the executor / administrator gets the same fee as the lawyer. So you're talking double this amount based on that value for attorney and executor. They each get that. So that's expensive. You know, that's a lot of money. That's a lot more than you'd be spending on setting up a trust. It's maybe worth it if you're in that position to get a trust, even if there's a lot of hassle going to the banks and such, getting them into your accounts, you know, but. Okay, switching gears. Any questions so far? Anything on trusts or wills? Yes?
An executor very well be named in the will, so they would be inheriting whatever they receive in addition to their fee.
Yes, yes. They can always waive their fee, okay, but they're entitled to one. But a lot of times siblings, one of them is named as executor, they may choose to waive it. They may choose not to and say, no, I want it. Causes some hard relations, but if they take a fee, they pay income tax on that. It's a fee, it's earned income. If they waive the fee and just take it as an inheritance, no income tax on an inheritance. When you receive an inheritance or a gift, the recipient does not pay any income tax on that. That's free of income tax. So, any other questions so far, wills or trusts? Okay, switching gears just a little bit, just briefly, irrevocable trust. Completely different animal. This is used primarily for 2 or 3 purposes. Mainly, it's used for if you have a disabled person in your family that you want to take care of, and this disabled person is going to get some government benefits, is going to be on Social Security disability, you want to leave some extra money to take care of this person over and above what Social Security will pay for their health, care, and maintenance. You put it into an irrevocable trust, and then the government can't get those assets. And it can be used for them during their lifetime, and then you say in the trust, after they pass away, what is left in it goes to somewhere else, your other family members or charity or whatever. So that kind of trust is called a special needs trust. It's for people who have special needs due to disabilities, and they're getting government benefits. So you don't want to leave it to them directly, because then, like I said, with the example of the elderly lady who's in a nursing home, you want to leave something to mom who's in a nursing home, but if the state's already paying for a nursing home, you don't want to give her any money, because it goes right to the state, all of it then. You just leave something there for the extras, for the hair, for the whatever. You know, it could be for music lessons, it could be whatever the state's not paying for it, you want the person to have benefits of. It's also used for reducing estate taxes. Estate taxes, we're going to talk about in a minute. Each person can have, in 2019, $11,400,000 of assets. It was raised significantly January 1, 2018. It was $5 million and change. Now it's 11.4. 11,400,000. Each of us can leave to whomever we want at death, no estate tax. But what if you have 30 million of assets? Well, what happens very often then people say is, I better start getting it out of my hands. Because if I have 30 million, I'm allowed to leave 11.4. There's close to 20 million there being taxed at 40%. So how do we reduce that estate tax burden? Get rid of it while you're alive. Put it where? Give it to the kids or grandkids now? I don't trust them now. I give them all that kind of money now, they blow it. Set up an irrevocable trust. The kids and grandkids get it at certain ages. Name a trustee to manage those assets. You can't be the trustee of that irrevocable trust. You can't have control over it. You have to separate from it. Then it's out of your estate. So if you die, it's out of my estate. Okay? So you can give it away while you're alive. And we'll get a little bit more into that. We're going to talk about estate and gift taxes in a little more detail in a minute, but that's what it's used for primarily. And for charitable purposes as well, which also could be to help reduce estate taxes as well as income taxes. I'll give a plug for Cuesta College. Let's say you have money, you want to give money to Cuesta College or assets. Variety of these types of trusts, GRITs, GRATs, GRUTs, CUPERTs, grantor retained income trust, grantor retained annuity trust, grantor retained unit trust, qualified personal residence trust. So you can give assets to an irrevocable trust, and you could say, maybe it's a stock that's paying a high dividend, and you have 1,000 shares of General Mills paying close to a 4% dividend now. And you've always ate your Cheerios and you love General Mills and you bought, $500,000 worth of stock over the years of General Mills, paying a nice dividend. You could put that into an irrevocable trust, and you could say, I want to retain the income. I want the dividends while I'm alive. Grant a retained income trust. I need that dividend still coming to me, but when I die, then the assets that are left there, those shares, then they go to this charity, Cuesta College Foundation, wherever you want it to go, okay? And you could switch it around. You could say, well, wait a minute, I'll give the income now to the charity. So they get the dividends, but when I die, they don't get the stock. Then it goes to my family members or somewhere else. So those are the different types of ways you can give assets into an irrevocable trust, get them out of your estate, either in whole or in part, but when you give any of it, you have to lose control over it. You can't be trustee, you can't be beneficiary, and you get one shot at writing that trust document. It's not revocable, it's not changeable. The only thing you can change, I've done this a lot of times for years ago, when the estate tax exemption amount was $600,000, as recently as early 2000s. Okay? And so people have $1 million and they say, well, I got 600,000 I die with and 400 is gonna be taxed. What do? Set up trusts for the kids and grandkids. I did one for one lady, 9 separate trusts, 9 kids and grandkids. Back then it was 11,000 a year, now it's 15,000 a year you can give away. So she started putting that into the trust for the kids. And she said, grandkids, you get so much at age 25, you get it before that to use for college, you get so much at age 35, okay? Start putting money into there each year, those irrevocable trusts. You get one shot at saying who's gonna be the trustee and successor trustees, who's the beneficiary, when's the beneficiary get it. What do you do if all of a sudden the 14-year-old granddaughter who you've been putting money into every 3, 4, 5 years, you lose faith in that person, you go, I don't wanna give any more money. What's in the trust stays, you can't change it. You should stop putting more into that trust for that grandchild if you say, I don't want to get that one anymore. But you can't get it back once you put it into an irrevocable trust, okay? Life insurance is very often put into an irrevocable trust. When people have quite a bit of assets where they say, we're gonna wind up paying estate taxes, especially if it's assets that are not liquid. So you own land, you own a business, you have a business that's worth 20 million. You have a parcel of land, a ranch, a farm that's owned for years in the family, and you have it now and it's worth a ton of money, the land value. You die and you have 20 million of land, that's gonna be a taxable chunk of, 4 or 5 million that's owed the IRS. Who's gonna have the cash to pay that? We're gonna have to sell the land. So what people do very often is they buy life insurance just to be there to pay the estate tax bill. Problem is, you buy 4 million or 5 million of life insurance, that's part of your estate as well. So now you're really only getting 60% of the value of that life insurance to be able to pay the bill. So you gotta ratchet up the amount of life insurance you buy. How do you get the life insurance out of your estate? You set up an irrevocable trust. The irrevocable trust, you put in enough money for the trust to buy the life insurance on your life. You're just putting cash into the trust each year to pay the premiums on the life insurance. The trust buys the policy on your life. Now that life insurance is not part of your taxable estate. Now, if you already have an existing life insurance policy, and you go, okay, this is good news, but I gotta get that out of my estate. Put it into an irrevocable trust, but because you already owned it first, you have to survive for 3 years after you put it into the trust for it to be out of your estate. So if you're not sure how to do this, talk to a lawyer, set up the trust, have the trust buy the policy first. Then you don't have to survive 3 years. It's out of your estate right from the get-go. Okay? Irrevocable trust, complicated, really complicated, but really to save estate taxes. Okay? Joint tenancy, people think, well, I can avoid probate. I have adult child or 2 or 3, put the kid's name on the accounts as joint tenants. Put the kid's name on the deed to the house, sign it over to me and the child as joint tenants. When I die, no probate, goes right to the kid I want it to go to. True, it would, but that causes problems. One is you lost control. I had a client, an elderly lady, who came to me. She was a widow. Her son, 40-ish, a couple years earlier when dad died, she executed a deed to herself and her son as joint tenants. So when I die, it'll go right to him, no probate. True, now here it was 5 years later, she's in her mid-70s, she doesn't want the house anymore, she wants to downsize and get a condo. He has to sign. He didn't want to sign. He wanted the house when she died. She's stuck. She can't sell that house without him approving it. You can go to court and force a partition of a joint tenancy property now, but he has a right to half that property. Who's going to buy half a house? You know, I mean, you could theoretically sell it, but nobody practically wants to buy that. The kid wanted to, I talked with the son, he wanted to live in that house eventually. He wanted to raise his kids in that house. He had a couple young children. Go get a mortgage, buy the house from your mom, let her get out of it, but you're holding her up here. So we wound up helping him get a mortgage so he could buy the house, but he held her up for a good 6 months until he was able to get a mortgage. And so that's not good. Bank accounts, put the kid's name on his bank account, kid can take the money out. They have the right to do that once you put them on as a joint tenant. You create a joint tenancy with a non-spouse, you might be creating a taxable gift just by putting their name on the account. Putting their name on the account, not so bad, but when they take the money out of the account, that becomes a gift because you can't get it back. Putting their name on a deed, that's a gift right then and there. So, gift tax problems. Creditors of the adult child who you put on, they can get those assets. So you have a child who's going through a divorce or gambling problems or whatever, they have creditors, shopping addictions, they don't pay their credit card bills, they can come after the assets that they're entitled to as joint tenants. They can go after that. So not a good idea usually, creating joint tenancies just for avoiding probate. Not worth the risk, in my opinion. All right, switching gears again. Guardian for your minor children. There's two different roles here, and they do not have to be served by the same person. You have a guardian of the estate and a guardian of the person. The guardian of the person, who's going to be the person you want to take custody of your minor children if you die. That's who's going to live with the child, food, clothing, shelter. That's who has physical custody of the child. Guardian of the estate is who's responsible for the legal affairs of the child. So if the child is coming into money, the guardian of the estate manages the child's money. Maybe there's a lawsuit that is going to be needed to be filed on behalf of deceased mom and dad on behalf of the minor children. You know, if I get killed and my wife's with me, we get killed by a drunk driver, who's going to file the lawsuit? If we had minor children only, well, they're the ones who would be the ones suing. Hey, we lost our mom and dad. The guardian of the estate files it for them. So you don't have to have the same people. Sometimes you say, well, I want my sister-in-law to raise the kids, but I want my brother to be guardian of the estate. He's a CPA, she would be great, cousins of the same age, we'd be okay with that. Fine, as long as you have those people aware who's doing what and that they would get along. Because the guardian of the person is going to have to go to the guardian of the estate, say, I need money for this and that and the other thing, and make sure they're on the same page. Of course, you talk it over with these people and say you're willing to do this, and you name first choice, second choice, third choice. You could have one person do both. I mean, if you're comfortable with that, that's fine. What it comes down to is the court still has to pass judgment on this. And you do this in either a will or a separate document. Most people, when they first have a child, they start thinking about, oh, I should do a will, name guardian. And that's where it's very often done, in the will. But you don't have to even do a will. You can just do a separate document. It gets notarized. It's like guardian of the estate, guardian of the person. If we die, here's what we want. Here's what I want. So you don't have to go through even doing a will. It could be a separate legal document. But when you both pass away, then the court appoints guardian of the estate, whoever is nominated by the parents, unless that person's found to be unsuitable. So if that person has some fraud convictions, has some trouble with money, and another family member steps in and says, oh, no, that shouldn't be the case, and brings forward evidence, then the court might say, sorry, we're not going to do the deceased parent's wishes. Guardian of the person, again, the court has to look at the parent's choice. They give due consideration to that, due weight to the parent's choice, and they also give due weight to the child's choice if the child is of sufficient age and has a reasonability to express an opinion in the judge's opinion. Is this a 12-year-old or 13-year-old who seems to be with some reasoning capacity that I'll take into consideration? They will. If the child had already been living with another family member, that's going to be taken into consideration. If that was a good household, they'll give some preference to keeping the child in that same household for guardian of the person. But this is something, I think a lot of young families, you think of this before you even think of giving assets away, because you don't have a whole lot of assets at first. You just got to think of who's going to raise the kids, who's going to control their finances if we both kick. So, okay. Federal state tax. It's a transfer tax. It's kind of offensive in some people's opinions. When you think about it, all your life you accumulate wealth, but every time you accumulate wealth, either from a job you've earned money, a business you've made money, you took some of that money and said, well, I'm going to go do something with it, but wait, before I go do something, I have to pay income tax on it. Every time you get money during your lifetime, through earnings, through dividends, through interest, through investments that appreciate and you sell them, the income tax takes a piece of you. The income tax works against your accumulation of wealth. So look, over the course of a lifetime, you've been very successful at accumulating wealth, you've been a good investor, and despite the income tax, you built up 20 million of assets. You want to then leave it to your family when you pass away. Well, you can leave it to a spouse, no estate tax. Transfers to a spouse or to a charity, no estate tax. But other people, the children, anybody other than a spouse or a charity, there's a tax on your right to transfer those assets. Anything above this exclusion, which is now pretty hefty, 11.4 million. But the way the law is, this is always in a mess. In 2027, I believe it is, it's scheduled as the law is currently to go back down to 5 million, unless they do some negotiating, which depends who's in power then, they may or may not. But for now, it's 11.4 million. Beginning in 2011, we were able to get this thing called portability. So each spouse has 11.4 million today. If you leave it to a surviving spouse, okay, surviving spouse says, when I die, I have 22.8 million I can leave to the kids tax-free because I could use the first spouse's exemption. It's portable, it comes with me, okay? So that's of significant value now. We didn't have that before 2011. Before 2011, it was like, hey, if they're getting close to that exemption amount, let's have this spouse use his or her exemption. Don't just give it to the surviving spouse because the surviving spouse only has one exemption to use. So you would set up what's called a bypass trust back then, or credit shelter trust. First spouse dies, don't give it to the surviving spouse. Use my exemption amount. Put it in a trust that my spouse can get access to, but when I die, it's not considered part of her estate. It has its own exemption that I was able to use. Now we don't have to do that. We can just say, give it all to the surviving spouse. Surviving spouse, if need be, can use both exemptions. But to get that portability, when the first spouse dies, you do have to file an estate tax return, a Form 706, and you just have to elect portability, saying first spouse isn't using his or her exemption amount. It's going to be used possibly by the survivor if needed. You don't file that 706, you don't have portability. So just another little piece of work when you pass away for your accountant or lawyers. The market value of your assets, when they say 11.4 million, everything you own at death or the date 6 months after your death, take the value either date of all your assets. And that's the value you use to decide is it above or below 11.4 million, okay? Gift tax, another transfer tax, but this applies during life. It's an enforcer for the estate tax. Think of it like this. 11.4 million you can give away at death, no transfer tax there, called the estate tax, or during life, no transfer tax there, called the gift tax. The same 11.4, use it when you want, at death or life. Why do we have this gift tax? Because if people could give away all their assets during their lifetime with no transfer tax, you're sitting on 30 million and you're getting old, or you're going through a major surgery and you're 85 years old and you go, you know what, 11.4 million, I'm going through this surgery, I better give this stuff away to the kids now and grandkids. So you give away 20 million now. You sit on 10 million, you go, if I kick it, I don't make it through the surgery, no estate tax. Here, kids, line up before I go into the surgery, take a few million each. And what happens? The IRS says, we didn't get ours, you know. So we're not gonna let you do that. You can't give it away during your lifetime, not too quickly at least, 15,000 a year. And that just went up, that goes up slowly. 2018, it went up 1,000, ooh, 15,000 a year you can give away. Free of estate tax. Anything beyond that, you're starting to eat into that 11.4. So you can give away a lot during your lifetime, still 11.4, but if you gave away 11 million today, say 11 million 15,000 to your one child, that's 15,000, 11 million 15, oh, 11 million over the limit. All right, so you file a gift tax return saying, I don't want to pay gift tax now, just use some of my exemption amount. Then you'd have 400,000 left you can give away at death free of estate tax. See, so it's just whatever you use in life, that's that much left you have to use at death free of the estate tax. Okay, so, but again, you can give as much as you want to your spouse while you're alive. Okay, so, and you can pay for medical expenses, tuition, and look what they wrote into the gift tax code. Isn't that something? Hey, you give us as much as you want while you're alive, you know. I'm surprised they didn't put that in the estate tax as well. It's just in the gift tax. I mean, it's like, that's pretty bold. I mean, so you give us your money and, you know, hey, we won't put a gift tax on you, you know. So, and then finally wrapping it up, durable powers of attorney. What does this mean? Well, a power of attorney means you're giving somebody else authority to act on your behalf. You're giving an agent who you choose the authority to sell real estate, go to your bank account, take money out, okay? So they can deal with your assets. Durable means that the agent's authority will continue through your period of incapacity, which is what you want. That's really ideally what you set it up for. If you become incompetent, then your agent can go do your banking for you, sign your tax returns, sell the real estate. You don't need a conservatorship then. You have an agent do that thing. It would be, in my opinion, it'd be silly to do a power of attorney that's not durable. Only reason you might do it is if it's for a limited time, a specific transaction. Hey, our house is for sale, but we're going on vacation for 2 months to Europe. Stay here, Sean, and be my agent under this power of attorney. If the house sells, you can then sign for me, okay? So that would be fine, and it wouldn't need to be durable. But generally speaking, for estate planning purposes, you want it to be durable. Springing power of attorney, I think you also want for estate planning purposes. You're healthy, you're fine, you don't need your kids to have any authority now to act on your behalf. You say that the agent's authority comes to life or springs up when you state in the document, like you did in your trust, when the doctor says, I no longer can act for myself. So the attending physician says, I'm incompetent, now my agent's authority begins. Not when I sign the document. You sign the document now and it says, agents, here's who you are, you give them copies of it, but your authority doesn't begin until an attending physician certifies I no longer can act for myself. Then it springs to power. So, and agents under a power of attorney, again, it could be a bank, it could be a trust department, it does not have to be a human being. You could name co-agents, but then all decisions have to be made unanimously. Not a good idea usually. I mean, it could be depends on the family dynamics. I usually advise choice 1, choice 2, choice 3. You know, who's good with the finances, who do you trust? Name one at a time to act. If one doesn't want to act, the other one jumps in and acts. With or without a living trust, these are good to have, okay? So, advanced healthcare directives, to wrap it up. I know I'm running about 6 minutes, 7 minutes over, and we're gonna wrap it up in just 2 or 3 minutes. This is allowing you to state your wishes for end-of-life healthcare. Do you want to be kept alive on machines? Do you not want to be kept alive on machines? You also, in an advanced healthcare directive, can name somebody as an agent under a power of attorney who will make those medical decisions for you if you're not able to make them. So this is useful to have, and it's not just for old people. I have two sons who travel quite a bit. I told them, we should really get one of these for you. I mean, you're in your 20s, but you get in some kind of accident or something, and you're just laying around there, we should have this. And something happens where mom and dad are with you and we go down, who's making these decisions for you? So anybody who's doing a lot of traveling, or if you're elderly, you should get one of these. The agent has authority even post-death with regard to an autopsy, which you never know. Maybe you want an autopsy. The hospital doesn't do one unless the law enforcement requests it. So if there's a death and you say, well, there's no legal law enforcement issue here, but we want to know, like, why did a healthy person die? What they eat? What's in their stomach? What happened? Were there some drugs given to them? So you might want one. Your agent under the power of attorney, under the Advanced Healthcare Directive. And by the way, Advanced Healthcare Directive is a term that could include two different documents or both in one. Advanced Healthcare Directive means power of attorney for healthcare and or end of life authority to pull the plug. But you put those usually into one, and that's called the Advanced Healthcare Directive, but individually they could be called an Advanced Healthcare Directive as well. Okay? It does not allow mercy killing or euthanasia. Your agent, can't go down that road, but they can say, I withhold nutrition and hydration. But it's, if you say that you want that in the document, your agent hopefully follows your directions, okay? So, a little over, but that's a lot in an hour, in 9 minutes. So, any questions? It's complicated. You have an outline that gets a little deeper, and even this outline is condensed. I go through this and I think, it's getting too long. It's getting too long, but I'm trying to give you a little more detail. And you read this probate code, it just goes into all the what ifs. There's exceptions to exceptions, and it's just, but this is kind of as good as I can get it, fairly readable and condensable, but it still turns out to be 20-some pages on just a couple of the basic topics. We didn't really get into a lot of, other complicated issues that could be out there. So, any questions? Anything else I can go over for you? Okay.
Thanks, Gary.
Thank you. See you guys.